Regarding this matter of khul'i, this is also rampant, which our two eminent lawyers have raised. You see, there is a case whereby khul cannot be allowed. If a woman is able to convincingly present that she is being harmed by her husband and she wants out of the marriage and she wants to do khul, in such a situation, the judge cannot allow khul, but he has to force the husband to divorce her. And if the husband does not divorce her, the judge himself could divorce her, or he could give her the right to divorce herself. But the challenge with the judges is to prove the case of infliction of harm, al-idrar, because it is very, very difficult to do that. How do you prove that the husband is inflicting harm on his wife? Because she is the one with the only evidence. She is making the claim, and mostly because these are things that are happening within the confines of the home, there may not be witnesses that are regarded, that are expected. And I remember when we started drafting the law of personal status, the Grand Qadi of Kano State at that time, one of his urgent appeal is how could we find solutions to this problem of establishing harm, al-idrar. And it happened that the courts in the UAE, they were faced by this challenge as well, and they took the matter to one of the Maliki fuqaha, Sheikh bin Bay, who is very close to the Sultan, to come up with the position of the Maliki fuqaha on how can we establish al-idrar, that is infliction of harm by the husband on the wife. Because once the judge becomes convinced that the woman is experiencing harm from her husband, and it is because of that that he is indirectly coercing her to seek for khul'i, for payment, then he will not allow the payment. Even if she pays, if he later on has evidence that she was actually being maltreated by the husband, the judge will ask the husband to pay her back her money, but the divorce would have gone. So the question of khul'i is something that is very sensitive, and the specification of an amount based on bargain between the husband and the wife, this is something that judges, they need to show more discretion in that by looking at the case. There is a case, by looking at it on a case-by-case basis. There is a case definitely when the woman, she just wants out. And the husband, he is not able to find what he will get to marry another wife. And in such a case, the judge definitely would look at what he has spent in marrying her, the time that she has spent, because the judgment of the Prophet sallallahu alaihi wasallam regarding this case, in the case of Qais ibn Thabit ibn Qais ibn Shammas, was that he gave her a garden, an orchard, and she said she wanted out. He said, why? He said, I just want out. I don't love him anymore. He said, will you take back his orchard? Will you give him back his orchard? She said, I will give more than that to him. So he said, take your orchard and divorce her. So it is based on this that what is paid as dowry at least should form, it is what is to be repaid back. And now how much are people paying? 30,000, 50,000 as dowry. The only question will come regarding kayan lefe. Must she also pay the equivalent amount of kayan lefe, because kayan lefe is treated as dowry? This is left to the discretion of the Qadi, because as we saw in the Muwatta of cases in which Sayyidina Uthman adjudicated, he gave the discretion to the Qadi. And in doing that, we need to really, as advocated by my sister Hajia Sauda, that judges, our Sharia court judges, we should have more engagement with them, especially under the umbrella of the Supreme Council or a foundation like the Sultan Foundation, in which to decide on these cases based on the social evils that we are seeing.